Hey guys, good morning. We're going to look at the application for interlocutory appeal by Trump and other defendants in the Georgia case brought by prosecutor Fani Willis. Of course, this comes out of the judge's ruling that he was not going to disqualify Fani Willis from proceeding with prosecution and force someone else to be on it. He's not going to dismiss the case either, right? He gave them the choice of Nathan Wade resigning, and that's what he did. So for Trump to appeal that, he has to have permission from the trial judge, a certificate for immediate review that was granted by the judge. Then he has to not just go ahead and appeal. He has to convince the Court of Appeals to allow him to appeal. And that's because this is an appeal before the trial occurs. So it's an interlocutory appeal. And because of the type of appeal it is, he has to have permission to move forward, not only from the trial judge, but also the Court of Appeals. So he's at this next phase where he's asking the Court of Appeals take this case. And there are certain reasons why they take cases and certain reasons why they don't. They're not really at this point going to, they aren't going to decide the appeal on the merits. First, they have to decide whether they actually want to do it or not. So that's what's up right now. And we'll hear back from them probably pretty quickly on this. So application for interlocutory appeal, should the Court of Appeals in Georgia take this case? Now, obviously, if you're pro-Trump, you think yes, because you think the trial judge made a mistake, right? But I think you could also be anti-Trump and still think they should go ahead and decide this now because it's of paramount importance. If you get to the end of the case and the judge has made a mistake, it's all null because this is something that would cause a reversal of a conviction. It's not a harmless error situation. And Trump's right about that. Now, they don't have to hear it, but they could. So we'll see what the arguments are for that. But I think they probably should, because of the magnitude of the case and the importance of this issue, go ahead and decide it. All right, so first thing to start was the table of contents, and we won't dwell on it because we'll look at the things that are important in it. And it's largely going to be inside the argument where they say the application should be granted because it's structural error. In other words, if this happened, the conviction is out. We're not going to examine it and see whether it really mattered or not. If you have this situation, the conviction would be out. So it's a structural error, they say. And also they say it can clarify precedent, and you'll see why that's important. And they also say, well, even with the precedent that exists and on the factual findings the judge made, he made a legal error in how he determine whether there was a conflict or not. And we'll go over those in a little more detail. So I'm just going to scan through it. Here's the table of authorities that they have to give, all the cases that they cite. There's a lot, right? You'd think with so many cases cited, the law would be extremely clear here, but it is murky in the parameters. That's an argument here made by Trump's team. I had a lot of pro-Trump people tell me there's nothing murky about it. But if that's true, then why is Trump arguing that they could use more precedent in this area? And you'll see there, some things are clear, but some things are not exactly clear. And that's part of the issue. And even the trial judge said that in his ruling. All right, we'll skip through most of the introduction because I don't think you're coming into this blind as to what the real issues are here in terms of the factual part of it. So Trump's team made some highlights here where I saw things that I thought were worth discussing. The trial court factually found D.A. Willis's out-of-court statements to be improper. And he did do that. And defendants proved an apparent conflict of interest. The court erred as a matter of law by not requiring dismissal and her disqualification. Well, I think that, the judge said there was an appearance of impropriety. He did not find an actual conflict of interest. And that is an important dividing point, because does the law require, if there's not a conflict, an automatic disqualification if it's just an appearance of impropriety? I mean, that's part of what this appeal is about, because the judge said the law doesn't require that. And it's also an argument of whether there was a conflict of interest, because if there was one, which even the judge agreed, and so did the state, if there is an actual conflict of interest, then the DA has to go. But the judge found there was not. He said there was this appearance of impropriety. So that's an early shot here. What is an important issue? So they say, look, first, the erroneous failure to disqualify a prosecutor is a structural error that would not just cause substantial error at trial, would render each and every trial in this case a nullity. And that's true. So if there is an actual conflict of interest and a judge lets it proceed and that is found later, then the conviction would be reversed, to be a waste of time. And that's why it could be good to go ahead and decide right now if there is a conflict of interest, because let's say there is one, just hypothetically, then you put a different DA on it, hypothetically, and the case goes forward, and hypothetically there's a conviction. There's not that issue for appeal, versus if she moves on with the prosecution and later on they find she had a conflict of interest, it's all a big fat waste of time. Second, the need to establish precedent in the case for disqualification standard for forensic conduct is manifest, they say. So even Trump's team is saying we need some court of appeals precedent on this. We need you to tell us more clearly what the parameters are. And they say the trial court candidly acknowledged the lack of appellate guidance on this important disqualification issue significantly impacted his ruling. So they're saying even the judge said, look, it's not exactly clear what should be done in situations like this. And situations like this are pretty rare. And he said it's unmoored from precedent where he's at right now because there's not but so many appellate cases on this. So they're saying with additional and appropriate guidance from the judge, the ruling would have come out differently. It may be, but also it might not, right? And so the issue with precedent is it can come out in your favor or not come out in your favor, but either way, it might be useful. So they're also saying that the trial court found that the challenged actions, which hiring the paramour, Nathan Wade as lead prosecutor and accepting gifts and trips, created an appearance of impropriety in the case. And he did find that. Of course, he found they could cure it by selecting one of the two options, and the option selected was Wade resigned. But they're saying the trial court was bound by existing case law to not only require Wade's disqualification, but also the DA. So they're saying that this conflict of interest means she should go. And that'll get discussed in a little more detail there, because if it's an actual conflict of interest for the DA, she is supposed to go. The question is, if it's just an appearance of impropriety, does that mandate, the Apple thing's doing a thing. Does that mandate throwing the DA out? And that is slightly unclear. I think, I discussed in the first video where I was taking my best guess at what the standard ought to be, that if it's an actual conflict of interest, the person has to go. You don't have to show prejudice. And if there was forensic misconduct, you would have to show how that harmed you in some way. So you'd have to show that something was going on that would affect your rights in the case negatively. And if it was a mere appearance of impropriety, you don't have to take the DA off the case. That was my reading of it, and the judge pretty much read it that way, and he could craft this remedy. I also thought that if it's a mere appearance of a conflict, that they wouldn't hold that as a standard where the DA has to go. That would be interesting to see where they do clarify that, because their cases kind of say both. Then they say here, optimistically, the public's faith in the integrity of the judicial system, especially the criminal justice system, is critical to its functioning. That's aspirational. And I say that because it's pretty clear from the public debate on this that most people, or many people who talk, I don't know about most people in general, but many people who talk, they don't care about how this process is working. They don't care. They don't want to understand it. What they care about is if they don't like Trump, they just think that everything that Trump does in defense of himself is completely improper. And anything the DA does must be absolutely great, because they hate Trump and they want him not to be able to run and also to be convicted. Well, if you hate him, that's fine. And on the flip side, because you think that cases are political against Trump, there can't be any possible legal proceeding against him that is legitimate in any way, although you could imagine tons of ways that there could be legitimate legal process against the people you don't like. So the idea here is that when you talk about the system, is applying the actual legal rules to the facts and circumstances. And that's hard to do in politics, because there are improper motivations on both sides in politics. If you can't see that, if you can't see there are no angels in politics, I don't know. We just see the world differently. Let's put it that way. So in other words, I think no matter what the Court of Appeals does here, people are still going to think poorly about the judicial system if that's what they already think. There is nothing you can do about that in a political case. Some people will say the judge is corrupt and bought off if they don't like his order. They won't even read the order. They'll just go ahead and say things about the judge with no evidence, when their angst is over a case against somebody they support, of which they say there is no evidence. What can you do? And likewise, on the flip side, that, well, it's Trump, so he shouldn't be able to complain about any conflicts of interest of a prosecutor. He shouldn't be able to defend himself. He should speedily go into a trial court without exercising any of his rights. Okay, I hear that. Okay, all right, so whatever. So that one I think is on the low end of the stick there. While it would be nice if it were true, I just don't think that it is. But nevertheless, the business of the Court of Appeals should be to apply the law, and if it needs to be developed, to develop it. I'm skipping through here the factual predicate, because where it really matters, they'll talk about it down here. And everybody knows the story, right? That she was having a relationship with this guy who was hired to work for her, and that she was instrumental in having him hired. They went on all kinds of trips. Did she give him cash back? Did she give him all the cash back? Did she give him most of the cash back? It's all, and that. And then the church speech and then the testimony to trial. That's the big issue here. So let's get to whether the Court of Appeals should take this case or not. So they have jurisdiction. Court of Appeals has jurisdiction. They set that out as a predicate, but that's obviously true. Then they talk about the order appealed and some what they think are important elements of that. The order granted the defendant's motion in part and made 4 determinations, right? So they got to go to the Court of Appeals and say, there was a mistake in this order that is a serious mistake. You got to show that. You're not going to appeal for an order that's correct, right? So they say D.A. Willis does not have an actual conflict of interest in this case through her personal relationship and recurring travels with the lead prosecutor. That's one of the findings of the court that they contest. Second, there's a significant appearance of impropriety that infects the current structure of the prosecution team, and then they select 1 of 2 options to cure that. And of course, Trump's team says you can't do that. That if that's a reason to disqualify somebody, then she should go, they say. Third, the order denied defendants' motions to disqualify based on forensic misconduct. That's the talking, and they're going to say here what they contend is false evidence produced during the hearing. Fourth, and finally, that there's some technical things about the law here, which I'm not going to pay much attention to that because it's really about the conflict and forensic misconduct, I think. And then, of course, they say trial court gave us that certificate of immediate review that we needed. So here we are. So I also talked about in the last video that one of the hurdles Trump's team had to get over was, well, what would be the standard of review in this case? And if the appeal does go forward, that's going to be kind of important. And they attempt to split the baby here, and I think it's probably a pretty reasonable way. So they do note the law that reviewing a trial court's motion on ruling on a motion to disqualify is an abuse of discretion standard. We already knew that because we talked about it in the last video. And therefore, you give leeway to the judge, but in what context? So they're saying under abuse of discretion standard, the court should review legal holdings de novo. So in other words, if the judge flatly got the law wrong and said, well, I think the law is this, and I apply the facts to it and come to this conclusion, but what he said the law was wrong, that's de novo because that's a legal issue. But factual findings are within his purview, and then also deciding the weight and credibility, that's also within his discretion. So fact findings will be held up as long as they're not clearly erroneous. In other words, there's some evidence in the record to support them. So in other words, and as they say, they're generally operating under an abuse of discretion standard. That's not where you want to be if you're the person appealing. But I think they are correct that the legal aspects of the holding would be de novo because those are legal conclusions. A legal conclusion is not supposed to be discretionary. It's how you apply facts to that legal conclusion. It may sound kind of technical, and it kind of is, but they're trying to get the court to say you don't owe the trial court any deference on legal matters. That's for you to say whether the trial court is right or wrong. But on facts, you must give the trial court deference. All right. So they say whether the existence of a conflict of interest is there or not is a legal question subject to de novo review. So in other words, all the facts are up to the judge, but when the judge applies those, the conclusion of that should be a de novo review. Yeah, well, we'll see. We'll see about that. I definitely think the legal part of it, yes. And if you don't have contested facts and the facts aren't vague, so that if you just read these facts, the only conclusion is there's a conflict of interest, then I would agree with the de novo. But if you're assessing the impact of facts, then that would be an abuse of discretion. That's kind of how that splits. We won't dwell on this too long. I realize that this is not very interesting. So if the trial court does not apply the correct legal standards when disqualifying counsel, then the judgment should be vacated. Yeah, right. If you got the law wrong, judge, then your order must go. And that makes sense, of course. Then the next thing is, under Rule 30B of the Georgia Court of Appeals rules, you have to establish a reason for them to take this appeal early, because you can appeal at the end of the case when you appeal all the other things you may want to appeal, or maybe you don't even want to appeal because maybe you want to win in the case. So why should we be hearing your appeal now? What makes you special? Well, first of all, the trial judge said, yeah, I think this one merits it. But then you have to convince the Court of Appeals itself. And here's the 3 grounds. If you can show one of those, they're probably going to take the appeal. First is the issue to be decided appears to be dispositive of the case. In other words, it could end the case. And the order appears erroneous and is a substantial error at trial if wrong, and would adversely affect the rights of the appealing party until entry of final judgment. And the establishment of precedent is desirable. So they kind of admit on this first one that it's dispositive. And that's not true, because the case would still go forward if you just had a different DA on the case. Now, it could result in reversal later, but it's not dispositive at this point. And they kind of acknowledge that by saying, while disqualification is not dispositive of the underlying allegations, it would require reversal of the judgment if one is obtained. Well, that's assuming there's a judgment. So it's not dispositive. So that one's not going anywhere. It's just potentially reversible, like anything else could be if it happens along the way in a case. The more important ones are this issue of whether they buy the idea that if there's a conflict now, it would substantially affect the defendant's rights as the trial progresses, and it's a substantial error at trial if there is there. That makes sense to go ahead and decide that now, whichever way you may want to come down on it. But you can't say that automatically, or else you'd be hearing every one of these conflict appeals before the trial. I don't know that they want to go there. But the third one, establishment of precedent, is desirable. That's always going to be a winner if the Court of Appeals agrees with you, because then you're saying there's an element of the law that's important for people to know that isn't fleshed out, and we all need guidance on it, and it applies in this case. So that one, if they convince them, that's a good one. The second one's okay too, but if you create this general rule, you might be hearing more appeals than you want to. So let's see what they say. All right, the failure to disqualify a prosecutor is structural error that would necessitate reversal of any convictions. Right. So if there is a conflict of interest and you go through the whole trial, and at the end the Court of Appeals says, yes, there was one, or the trial court says, yes, there was one, or whatever, then the conviction's thrown out. It's all a big fat waste of time. So it is an important issue for sure. And they talk about the importance of due process, negative pretrial, they start to get into the facts, but we'll look at those later. The application should be granted to provide this court with the opportunity to clarify precedent and the forensic misconduct standard for disqualification of a prosecutor. So they're mainly talking about precedent in terms of forensic misconduct, saying that the trial judge, he himself found that precedent was underdeveloped, and he didn't think that he had the authority to deal with it in any way other than he did. But if the precedent were developed, Trump's team says it would come out on our side, so that's why we need it. And they start this off quoting Fani Willis. It's not really an issue of the law here, but you can see why they would want to put this in here. If I were to comment on an open case, any open case, it would be a reason to conflict my office out, she said, before she made these speeches. And now nobody who supports her wants to remember that she said that. But even though she said it, it doesn't control the situation legally, right? It's just kind of a dunk here. The issue is whether the law requires this or not. So the trial court explicitly found in its March 15th order that her extrajudicial statements were legally improper. And I've had some people tell me that because she wasn't disqualified, the judge said she did everything correct. And that is not what the judge ordered. Because of the way the judge ordered the things that he did, he really did set this up for an appeal, because he found wrongdoing of varying degrees, but not that fell into the two categories that required automatic disqualification, and gave him the ability to give this choice, right? So the judge did say these statements were illegally improper, and he even said maybe there should be a gag order. She needs to stop talking about it and all that. And the trial court expressly found there were reasonable questions about whether the district attorney and her hand-selected lead assistant district attorney testified truthfully. That's not good to have the judge write that about you. That is not good when you're the prosecutor of the case. But he said reasonable question. He didn't declare that the testimony was false, and that's a really important distinction for purposes of appeal. All right. He said he felt confined to stop short of disqualification due to the professed lack of guidance. So here they're trying to convince the court that the trial court felt that he couldn't do the full range of options because of the lack of precedent. And they made, I think, a good case for this. Whether it's successful or not, it's a different issue. But they say in the order, it said left unexplored, therefore, is how other examples of forensic misconduct can manifest. He's talking about left unexplored by appellate cases. And unmoored from precedent, in other words, he only has this Williams case and what it had in it. He doesn't really know what he could do, so he restricts the application of the facts to the Williams holding. The issue with that is, I think it's on this next page, is that the Williams case said in itself, here's an example of forensic misconduct. But what it didn't do was say, but here's how you decide whether there's forensic misconduct exactly, or what all the examples of it can be. And naturally, you don't want just examples. You want a test. You want to say something to say, if this happens, this is forensic misconduct. If you do this sort of thing. And there is a little bit of that. But all right. So in Williams, the Georgia Supreme Court said the standard to be applied for disqualifying forensic misconduct on pretrial extrajudicial statements of the defendant's guilt. Was it a calculated plan, Was it an inadvertent remark, just a side utterance or something like that? So the scale of this, all right, it matters, of course. Let's see, lack of legal precedent. So, lack of legal precedent for forensic misconduct, which does not involve prosecutors expressing their belief in a defendant's guilt. Because here, she didn't go to the church and go, they are guilty. She went to the church and said things that you could construe as being negative against them, right? Sorry, I meant to make this bigger, and now we'll do it. But she didn't say, well, these people are absolutely guilty. So it's a little bit different than Williams. And here it is. So they say in Williams, one of the primary examples of forensic misconduct is this extrajudicial pretrial comments in belief of the defendant's guilt. It's an example. But what if that's one example, it means there could be other things, and what are they? And they cite some things saying activity by a prosecutor to divert the jury from making final determination of guilt by weighing legally admitted evidence. And talk about that just because when you're on TV talking negative about the defendants and you say terrible things about them, you don't happen to say at that moment they're guilty, doesn't mean it is okay for you to do that. That's true, right? But I think really what it comes down to is, as the judge pointed out, at this stage of the case, do we really know that this is forensic misconduct? Do we know that the jury pool has actually been tainted because we're so far away from getting a jury? So that's an arguable point. And what Trump's team is saying is we need additional precedent here to talk about this. And maybe that, in fact, would be useful. Whether it's in favor of Trump or not in favor of Trump, it could be useful in the future if this sort of thing were to continue about people getting on TV and talking about cases, which ideally they don't. Then they talk about, okay, so they do say that, of course, obviously, that her extrajudicial statements are disqualifying. So they say they need the extra precedent, and they're saying, well, the stuff she did do would disqualify her. And they talk about the judge's ruling saying that even though the state said she wasn't talking about the defendants, you could read it as talking about the defendants, and let's keep it real here. Yes. And then also bringing it in as a racism against the guy when the argument was directed toward the dating, whatever you want to call it, relationship between them is really what was going on there. She was not admitting to that at that point. She was just claiming racism. That's not ideal for a prosecutor to be doing. I understand if you hate Trump, you think prosecutors should be able to go on TV and say whatever they want to say. But from a system standpoint, that's not behavior that you want to encourage, because not every defendant would be somebody you hate. And under the doctrine of what's good for the goose is good for the gander, you want rules to apply equally in terms of the law. Anyway, I'm not saying necessarily that I agree that it's disqualifying forensic misconduct. I'm making a point that it shouldn't be happening. And even, of course, the judge agreed with that. All right. So let's see. They also say here, which is a more controversial, I think, is that her submission of a false statement of false testimony is disqualifying forensic misconduct. I say more controversial because people argue even harder over this from what I've seen. And they make 2 points. One, that she knowingly filed a false sworn affidavit of the prosecutor, Nathan Wade, that she knew it was false at the time that it was filed, they're saying. Therefore, she perpetrated this fraud upon the court, they're saying. Did she know at the time? They also say that she lied to the court under oath, right? Which would be bad. I think if you have a prosecutor who lies under oath in the middle of a case that she's trying to prosecute, you should be off the case. Question is that the finding of fact? And look at the footnote 13 here, which they have to admit, but put it in the footnote. The trial court stopped short of making a specific finding that DA Willis lied to the court, saying that the court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court, and arguably gave untruthful testimony. Now, that's a problem on appeal, because remember, the discretion says the trial judge makes the decisions on fact. And if there's anything to support it, you're supposed to go with what he says. It's only the legal conclusions that are de novo review. So it's hard to ask the Court of Appeals to go back and say, the judge decided that there were open questions on whether this was truthful or not, but the judge considered that in terms of his ruling and then decided that he wasn't going to decide whether it was untruthful. He was just going to say there were questions about it. Are you asking the Court of Appeals to review the record and say, no, we decided that she lied? That's a tough one. The best that you could hope for is that they would send it back and say, you have to decide whether she lied or not. And I don't know that they'll do that or not, but they're not really usually in the business of finding facts and overruling a court on facts and then finding contrary facts. It's not really what a court of appeals is supposed to do. All right, so they're saying that she continued to have this behavior, even though she'd already been disqualified because of an actual conflict. And they say that in terms of Judge McBurney's order, and say, by the way, you could just use that and say she should be disqualified. But it's in a footnote. It's probably not their best argument if it's sitting in a footnote, right? Then they also say below, they maintain below that dismissal is a truly appropriate remedy. And of course, if you're a defendant, that's what you want, but that's unlikely to occur because at this stage of the case, you could replace her with a different DA if she does have this conflict or is disqualified. So you don't have to have dismissal. So if you're a Trump fan, you want dismissal, you're facing an unfortunate reality on your side that they could cure this hypothetically if it is a problem, but just by saying she has to go, let them have a different DA. Now, what that person would do with the case, might be completely different than what she's doing with the case. They might move forward with it. They might throw it out. Who knows? You don't know. But they say her disqualification is the minimum that must be done. Now, however, the trial court said, well, no, the minimum is let's just get rid of the appearance of impropriety about the money and tell her to stop talking about the case. That's what he felt the minimum was that he could do, or the right thing he could do. Let's see here to some more stuff. All right. So the failure to find an actual conflict was wrong, they're saying. And that's important, I think, because it is clear. Nobody can argue under Georgia law that if there's an actual conflict by the prosecutor has to go. You don't have to show prejudice. So I don't think they should only stick on appearance of impropriety when there is a clear ground under the law that would make her go. They got to argue it, right? Of course, here the judge said, well, there is no actual conflict of interest, which they disagree with. They say DA Willis acquired a personal disqualifying interest necessitating her disqualification of the case. And then they say a personal disqualifying interest can arise from an actual conflict of interest or an appearance of a conflict of interest. Yeah, well, actual is certainly the law. Appearance, there are cases that use that language, and then there are cases that don't use that language. And personally, I think they could probably use some clarification on that issue because both sides have cases to point to. But there's also the issue of you have to go if there's an actual conflict of interest, but if there's this appearance of impropriety, can you do something to mitigate that since it hasn't gotten to the level of actual conflict? And that's what the judge did. All right. So they're saying, however, just on the facts found by the trial court itself, which is what you need to do when you're on appeal, you need to say that an actual conflict of interest exists. So they're saying the judge found the appropriate facts, but applied the law wrong, and you need to fix it, they're saying. Is that true? Well, the Court of Appeals could decide that because it's a legal conclusion. And they are saying, again, there was false testimony. But remember, in the footnote, they acknowledged that the trial court didn't actually say it was false, which is a problem, even if it was false. And they make their claim right here, by God, whether an actual conflict or an appearance of a conflict exists, the law requires disqualification. So they see the definition that big. The state only saw it as an actual conflict, which I tended to agree with based on the cases that I read. However, there are cases that also include the language of appearance of a conflict. So I can't say that what they're saying is frivolous here. It might even be right. In my mind, they could clear this up because they have said both things in the past. And they talk about here, people pointed out that she filed certification saying she got no gifts or benefits in a yearly aggregate of $100 or more. That may indeed be false and probably is. Who knows? But it's in the footnote, that's where you put your most compelling things, right? From a legal standpoint, probably not. But some of these things that make sense for having the appeal, I think that's for sure. They talk about public officials cannot reap personal financial gain at the expense of the public. So this goes back to him paying for trips and things. A prosecutor cannot acquire personal stake or interest in the defendant's convictions. And there's an intellectual issue here in terms of with that word conviction, because hiring the boyfriend and paying him during the prosecution and going on trips with him, let's say that's improper, which I definitely agree that it is that a stake in conviction? It's a stake in the prosecution and the proceeding of the prosecution. And I think that it could be said there's a conflict because of that. Now, the judge decided it was an appearance of one and said if he goes, that's gone. I get that. But sticking with the idea that you shouldn't have that ongoing in a case, it's not really a stake in the conviction, though, because she's not going to get more money from Wade if there's a conviction or not. She gets more money from Wade, hypothetically, if the case stays on longer and he can make this money and then share it with her, right? So the judge, I think, even said at one point, there's no evidence that she's tried to lengthen this case. In fact, she wants to go ahead and get it over with. So the money's not causing her to string out the case, and the money's not why she brought it. Now, I agree with both those things, but I also agree with the idea that you can't be doing this. I don't even understand how people that hate Trump can go, well, it definitely should be okay for a DA to hire somebody they're having a relationship with, not disclose it, pay that person tons of money, and then go on trips with them that person's paying for, and it's all okay as long as you say, well, I gave them the money back in cash. I don't understand that, except for the fact that if you hate Trump, everything is okay as long as it goes against him. And also, if you like Trump, everything's okay that he does. I get that part. I do get. All right. So they say courts regularly disqualify private lawyers for an appearance or possibility of a conflict. And that's where I say they do cite some cases that support this. And they make this contention here, which I think would be good, whether the Court of Appeals would clarify this or not. When there's an appearance of impropriety, disqualification must follow. Is that true? If it is true, if that's a correct reading of the law, then the judge did commit a legal error, because he did find there was an appearance of impropriety, and there was one. I mean, there definitely was one. If the law says disqualification must follow, then she should have been disqualified. The judge shouldn't have been able to give her the option to stay on the case if she let go or her boyfriend resigned. That would be improper if it's an automatic disqualification, just like if it were an actual conflict. So this is an important point of the law here, whether they're right or wrong on it, I think. And they cite some cases for that where there was at least the appearance of impropriety. There was the fundamental fairness was denied. So they have case law on their side. Trust me, there's cases that say the opposite of this, which is you have to have an actual conflict of interest to mandate disqualification of a district attorney. And that's why I think the Court of Appeals could come down on this and say, well, if there's an actual conflict, you have to go. If there's an appearance of impropriety, you have to go unless the judge can craft a remedy that would dissolve the appearance of impropriety, because that's what he did do. That's his best estimate of what the law will be. And they need to say whether that's correct or not. I think it would be useful for them to say that, at least. Don't you? I mean, they should weigh in and say, well, yeah, the way he interpreted the law is the right way, or he was wrong. That would be good to know right now, I think. And so now notice what they say here. The fact remains that the appearance of impropriety is distinguished from an actual conflict of interest can result in disqualification. Can is a different word than must, and can result in disqualification. I think it's something that even the judge wasn't going to say was impossible. He just didn't do it, because while it could do that, he also saw a path in his mind where if one of the two goes, the other can stay, and then we don't have this money issue anymore going back and forth. That doesn't make a lot of sense to me. Well, he didn't say one or the other. He said either way goes or your whole office goes. So really it did need to be Wade, right? So he's basically saying if you get rid of Wade, then you can proceed on. So if they didn't get rid of Wade, she would be disqualified. So the judge did definitely operate under the idea that it can result in disqualification, but not must result in disqualification. But earlier, the argument was, I'm pretty positive, that they just said, where there is an appearance of impropriety, then disqualification must follow. So that word gets used, and then the word can result gets used. So that's different. Those are pretty different, right? One allows a fashioning of remedy by the judge. The other is an automatic DQ. But then they come back to the strong language here at the end and say, because the trial court found there was an appearance of impropriety, which there was at that point, the law requires disqualification of them both. Is that true or not? That's what the Court of Appeals needs to decide. And then they argued about that. How could you just say that it affects Willis? And then how could you just let Wade go? That's not the right thing to do. So I think they've made the point here. I don't know that I'll find this page, so I won't even try to do it, that it would be good for the Court of Appeals to take this case, because it does affect substantial rights of the defendant during a trial, and it could result in the whole trial being a waste of time or not, depending on how the Court of Appeals comes down on this and whether there was a conviction or not. But also, I think they make a reasonable case here for precedent that they say they need on forensic misconduct. But I think their arguments under actual conflict of interest and appearance of impropriety expose some areas where the state's going to disagree on precedent, and the Court of Appeals could then harmonize that and come out with a standard. So I think this is a good case because of the high profile nature of it, for them to clarify what the law is in their state on these issues, the murky parameters of it. There are some basic principles that are very clear, but where they begin to intersect, it's not exactly clear what can happen here. And I think you're going to see the state say, well, we don't need any more precedent on forensic misconduct. The judge got it right. And they're also going to say the judge has an element of discretion when there's an appearance of impropriety and the judge did the right thing. They're going to argue. They may argue he didn't need to do anything, but what he did do was within his discretion, and there's no reason to challenge that. And that area of discretion is a little murky because one judge may see it one way and another judge the other, because when there's discretion like that on the remedy, then there's no mandatory disqualification like there is if there's an actual conflict of interest. So I think it is a case that could use legal reasoning of the Court of Appeals and to develop the law further for the state. So I think they should take the appeal, and that I think is true whether you think Trump should win this appeal or whether you think he shouldn't. I think it would be useful for that decision to occur. And how long that might slow the case down or not, it just depends on how they handle it. Right now, the judge has proceeded on with hearings and things, as we already talked about on the First Amendment motions and stuff like that. So I'd be surprised if they don't take this case, but nothing in the law is for certain. That's for sure. And maybe they won't, but I think they will. And if they do, then you will see a rehash of a lot of what they've already said here in the form of them actually briefing up the appeal and the state trying to persist it. In the state, I don't know, I didn't look further in the proceeding whether they can resist this application or not. Probably they can. And if they can, you'll get a preview of why they think the judge was correct in what he did, or maybe he didn't have to do all he did, but he was not outside the law in what he did. And plus, you don't need to hear this now. You can always hear it at the end of the trial. That's the normal procedure. Nothing special about this case. They'll say no need for precedent, no need to create a rule that every conflict case has to be resolved interlocutory in the middle of a trial. They'll make all those arguments to resist this, I'm sure. But nevertheless, I think the Court of Appeals probably should go ahead and hear it. That's my opinion, and yours might be different. And if you want to tell me, I'd be glad to consider it, unless you're raging out, and then I probably won't. Well, that's it. And let's get to here. And thanks. Bye.